He left the farm equally to his 3 sons, thinking that was the right thing to do. 6 months after the funeral, one of those sons filed a single court document, and a judge ordered the entire farm sold at public auction. The other 2 sons had no legal way to stop it. This is not a story about a bad son or a bad family. It is a story about a legal structure that most parents don't understand when they divide land equally among their children. Equal shares in a tenancy in common gives every heir the same right, including the right to file for partition. One person, one courthouse filing, no vote, no majority, no consent from the other heirs required. The youngest son had debts his brothers didn't know about. He needed his share liquidated. He hired an attorney, filed the petition, and asked the court to order the land sold and the proceeds distributed by ownership percentage. His brothers had 30 days to respond. They needed to either raise the full buyout price or watch their family farm go to auction. They couldn't raise it. The court ordered the sale. A partition action is a lawsuit filed by a co-owner of jointly held land asking the court to end the co-ownership arrangement. Courts have 2 ways to accomplish that. They can physically divide the land, giving each owner a separate deeded parcel corresponding to their ownership percentage. Or they can order the land sold at public auction and split the proceeds. Physical division, called partition in kind, works when the land is large enough and divisible in a way that gives each owner a functional parcel. A 100-acre tract divided 3 ways can sometimes work. A 40-acre homestead with a farmhouse in the middle usually cannot. When partition in kind isn't practical, courts default to a forced sale, and the forced sale is exactly what it sounds like. The land goes to public auction. Anyone can bid. The family members who want to keep the land have no priority over outside buyers. They bid the same as anyone else, and if they can't outbid outside investors with cash, they lose the land along with whatever emotional and financial investment they have made in it over their lifetime. In the case of this farm, 63 years of family ownership, 4 generations, a farmhouse and outbuildings the family had maintained and improved. It sold in under an hour. The 2 brothers who wanted to keep it walked away with their 1/3 of the sale price. The youngest son got his 1/3, and a stranger walked out with the deed. The partition trap gets set in the estate plan, often with the best of intentions. A parent wants to treat all children equally. Equal shares feel fair. Equal shares feel like the right thing to leave behind. And in many cases, there is no will at all. The parent dies intestate, without a will, and the land passes automatically to all heirs under state law. Multiple heirs. Equal fractional shares. Automatic tenancy in common. The partition trap is set the moment that land transfers without a recorded co-ownership agreement governing what the heirs can do with their shares. The problem multiplies across generations. One owner leaves the land to 3 children. Those 3 children each die and leave their share to their own children. What started as 3 equal owners becomes 9. Some of those 9 may never have set foot on the land. Some may desperately need money. Any one of them, holding any fraction of the original ownership, can file for partition and set the entire process in motion. Rural America has lost more family land to partition sales than to almost any other single legal mechanism, and in virtually every case, the family was shocked that one person with a small fraction of the ownership could force everyone else to an auction. They shouldn't have been shocked. The courthouse record showed exactly what the ownership structure was. The partition right was built into the deed from the day the land was inherited. Before a partition action gets filed, the courthouse record already contains everything needed to understand the risk. The deed or the probate distribution order shows who owns what percentage. The grantor index shows whether any co-owner has already conveyed their interest to a third party. The circuit court index shows whether any partition petition has already been filed. A co-owner can sell their fractional interest to anyone without telling the other co-owners, without their consent, and without any notice. An outside investor who purchases a fractional interest in family land acquires the same partition rights the original heir had, and they are far more likely to exercise that right than a family member who feels emotional ties to the property. Search the grantor index under every co-owner's name periodically. Look for any instrument they have filed conveying their interest forward. A co-owner who has already sold their share to an investor may not have told anyone, and the first sign may be a partition petition filed by someone the family has never met. The only reliable protection against an unwanted partition sale is a recorded co-ownership agreement, a document signed by every co-owner, properly executed and recorded at the courthouse just like a deed. A right of first refusal clause gives the other co-owners the legal right to match any purchase offer before an outside investor can acquire the interest. If the youngest son in this story had been bound by a right of first refusal, his brothers would have had the right to buy his share at whatever price the outside market would pay, keeping the interest in the family. A mediation requirement forces the co-owners to attempt a negotiated resolution before anyone can file a partition petition. Not a guarantee, but it creates a window of time for the family to find financing, negotiate a buyout, or reach a resolution that doesn't require a courtroom. A minimum holding period clause prevents any co-owner from filing for partition for a set number of years after they acquire their interest. This protects the family from a co-owner who inherits during a financial crisis and immediately moves to force a sale before anyone has time to respond. This agreement has to be recorded. A signed document sitting in someone's drawer has no more legal protection than a verbal agreement. It needs to be in the courthouse record, filed, indexed, and binding on every co-owner and every person who acquires an interest from them. Hidden power files is educational content. Laws vary by state. Always consult a licensed attorney for advice about your specific situation. If this is something every landowner should know, hit like so more people see it. He left it equally to 3 sons because that seemed like the right thing to do. He didn't know he was handing one of them the legal power to force the other 2 to an auction. That power was built into the deed the day the estate closed, and a single recorded document could have taken it away.